Hello everyone, let's start with a new chapter today, compromises, arrangements and amalgamations. This is chapter 15 of Companies Act 2013 and comprises of sections 230 to 240. So it has in total 11 sections which we are going to study. I would say that this particular chapter is a small chapter, has few important concepts, or you can say few concepts, few sections which are going to take a lot of time, but others are just easy to go and good to go. Okay, so before we start with section 230, what do you mean by these three terms? Compromises, arrangements and amalgamations. Now, for the first time I am telling you that even if you don't know the meaning of these three terms, it is hardly going to matter you in answering any examination question. Compromises, arrangements and amalgamations. Amalgamation is a term which we have often used in our accounting and other subjects, I would say. Merger, amalgamation, acquisition, takeover, such type of concepts you have heard a lot, and amalgamation in the nature of purchase, amalgamation in the nature of merger, you have heard a lot, right? Now don't at all try to relate those concepts over here, because law is something else, and whenever you are, see, law gives you the permission to do so. How you have to do so, that is also given in law, but now how you are going to, what effect it is going to bring into your books of accounts, that is told by accounting. So accounts tells us that how we have to record these entries, how we have to record the effect of amalgamation nature. At that time we need different identification. Income tax tells us what is going to be the taxability, what is going to be the effect. If it is absolute sale, then there would be sale of property, stamp value, etc, etc. If it is merger approved by this, that, so we have different laws. One topic cannot be governed by just one law. Okay, so if I'm talking about amalgamation for companies, Companies Act will also follow how you have to do accounting, that is accounts of companies, how they're maintained, accounting standards and everything, that also needs to be followed. So we are reading law over here. And amalgamation is a term which is very familiar to you. So you will understand, at least everyone, I think every student of mine will at least understand company A has purchased the shares of company B, or company A has purchased company B. Let's be very simple. That means we are just left with company A, or company A and company B have merged themselves, and the resultant company is company C. You know something, a concept known as transferor company. Here the transferor company is what? A. The transferee company is B. Here the transferor company is are you able to understand, are you able to recall which is the transferor company and which is the transferee company? The ultimate resultant company would be the transferee company, and whichever company is actually transferring its assets would be the transferor company. So here actually B is transferring, I have put the arrow incorrectly. Let me say B is transferring all its assets and properties to A. So the transferor company is B and the ultimate resulting transferee company is A. Here A plus B both are transferring their assets to C. So resulting company is C, that it is the transferee company. So we know such little terms that we might need over here. But what about the other two terms, that is compromise and arrangement? What do we mean by compromises and what do we mean by arrangements? See, often compromise is a word that we use very often in our daily life, because everyone is compromising nowadays. There was a time when everyone was living their life and was enjoying and content in what they have. Now everyone feels that we are compromising something. If I have got this less, see, I'm compromising. If he has got this more, see, I am compromising. So we are compromising everything. That is what we feel. Compromise is related to expectations. It is related to disputes. If you had some expectation from your friend, from one of your friend, and you both have a dispute amongst each other, there is one point your friend promised you that he is going to give you give you a book or something like that, and you were expecting a book from your friend, so there is some kind of dispute between both of you. Now if you agree, fine. If you are unable to get the book that you had promised for me, this is one book we have. For 2 days, I am going to keep this book, and for 2 days, you can keep this book. This is a compromise that this particular person is entering into, right? And this particular person is also compromising something, because had he got the book as he promised, he wouldn't have to share his own book. Now, what do we mean by arrangement? Arrangement can also be said the same thing. The only quite and little difference is that maybe even before this dispute has occurred, there wasn't any communication like you have to get the book, you don't get the book, you haven't got the book. There was not any dispute, not any fight between them. But because they both need the book, they both came to a conclusion that 2 days I am going to keep the book, 2 days you keep the book. Or we both can buy the book with a mutual money, and we can do it like this. So this is a kind of arrangement. So ideally, if I tell you, don't you think that compromise and arrangement are almost the same thing with very minutest difference, and it doesn't matter in law, it doesn't matter in this particular chapter, because everywhere where compromise is used, it is used compromise or arrangement. So it is hardly going to matter whether we say it's a compromise or arrangement. It would have mattered if the laws relating to compromise and arrangement were different, then it was imperative for us to identify which particular situation is a compromise and which situation is an arrangement. As of now, it doesn't matter to us. So compromise or arrangement is kind of same thing, where there is the terms are being altered for the benefit, for the mutual benefit, I can say. The terms between any contract, any arrangement between some companies, they're being altered, they're being created, they're being changed for the mutual benefit of both the companies. Now, can't I say the same thing happens in case of amalgamation also? Supposedly any company is taking over another company. Any company is taking over another company. We have Sun Pharma, which is taking over Ranbaxy. There are two pharma companies. Sun Pharma is taking over Ranbaxy supposedly. Now, when Sun Pharma is buying all the assets and properties of Ranbaxy, I would say this particular company is benefiting. Why is it benefiting? Because it is now going to expand, and this particular company will be merged into this. So it is somehow going to create a monopoly in the market, will have the benefits of a big player, a big market player ruling out other small competitors and all of things, right? How this particular company is going to benefit? The company's valuation, the company maybe, I have a share of Ranbaxy which is say for 500 rupees. Now this particular Sun Pharma, when it is acquiring Ranbaxy, it will pay me 1000 rupees. So it is going to benefit me. So they are doing some arrangement only. They are doing such kind of arrangement that I am going to buy all your assets and properties for our mutual benefit. So can I not say that amalgamation is also a kind of compromise and arrangement only with some additional things? Of course, I can say that. I can say that, right? So we have compromise or arrangement which can be internally in the company also, which can be externally with some other company also. If a company is taking over another company, or two companies are merging into one, that is amalgamation, that is merger. Okay, but merger, amalgamation, they also involve an element of compromise or arrangement in their scheme, in their whole process. I hope you have got this basic idea now. Now we'll start with section 230. Once we do a few sections, that is 230 and 232 basically, you will be able to understand and all your doubts will dispel relating to what is required in law. Okay. Now, arrangement also includes reorganization of company's share capital. I told you any arrangement can be internally within the company also. So you are rearranging company's share capital, that is also an arrangement. Okay, that is also an arrangement. When we do compromise, we are doing compromise. Whenever we are doing compromise, we will do compromise with someone we are already associated with. We are not going to do compromise with someone we don't know. If I'm going to compromise the situation, usually we say that husbands compromise with the wife. They are going to compromise with their own wife. They are not going to compromise someone with someone else's wife, right? Why do they need to compromise with them? If they want to amalgamate, then they will amalgamate with someone, other wife, right? Otherwise, compromise is going to happen in house only. Fine. So, arrangement includes a reorganization, includes, that means it is an inclusive definition. We are not saying, it is an inclusive meaning, I would say. It is an inclusive meaning. I'm not saying that this is the exhaustive one, that it only includes the reorganization of companies' share capital. No. By consolidation of shares of different classes and division of shares, or by both, by those methods, which you call as internal reconstruction. Combining shares into one, dividing shares into different shares, and likewise, right? So that is also a part of arrangement. Here, now we will start with the first section of this particular chapter, section 230, power to compromise and make arrangements with creditors and members. I told you, whenever we are making compromise or we are making arrangements, it is actually in-house. It is actually in-house, right? Of course, that merger and amalgamation also involve an element of compromise and arrangement which we are making with others. So someone will compromise something, someone will arrange something, of course, for the mutual benefit, right? So it also involves an element of compromise and arrangement, but as of now, under section 230, we are compromising with our shareholders. We are compromising with our creditors. Why? Why do you think anyone is going to compromise anything? Supposedly there's a company. I am a company and I owe an amount of 5 lakhs to Mr. X. So company has to pay 5 lakhs to Mr. X. Now I am asking the creditor. Mr. X is the creditor of the company because company has to pay to Mr. X. Now I am asking Mr. X that please compromise with me. Compromise with me, I will be able to pay only 2 lakhs. Why will the creditor compromise with me? Why will the creditor compromise? Maybe the financial position of me is not that good and the creditor is afraid that if this company turns into liquidation and if this company winds up, or even if it carries on business for 1 more month or 2 more months, it is actually going to spend all the money it has. So after that, I will not be able to get even 2 lakh rupees. I will not be able to get even 2 lakh rupees. When you are highly frustrated with any relationship or any situation which you can't get away with, you have to compromise. You have to compromise with what you get, what you have, right? Same is the situation with the creditor also. Creditor has to compromise. But creditor may agree, and some creditors are highly risk taking ones, so they will not agree. They will say no. Why will I let go my 3 lakh rupees just like that? No, I'm not going to agree. So there can be some creditors who agree to compromise. There can be some creditors who don't agree to compromise. What are going to be the consequences? Can any company do like this? Can any company threaten their creditors like this and actually enter into a scheme of compromise every now and then and let all their dues be waived off? This also doesn't seem really good, right? So we have necessary permissions required. We have proper procedure. How can a company enter into any compromise or arrangement, be it with the members, be it with the creditors? Members are the shareholders of the company and creditors the ones to whom company owes. It is only written creditors. It is nowhere written so far secured, unsecured. So the ones whose debts are secured by asset, it can be any bank also from which we have obtained a loan. So far, it's actually not written, but we will discover it. Okay, so it can be secured creditors, it can be unsecured creditors also. Now, compromise between whom? It is very clear, company and its creditors or any class of them. Between company and its members or any class of them. What do we mean by this? What do we mean by this? See, I hope you know the meaning of class of shares, class of debentures, class of creditors, anything like that. There can be, let's say, shares are issued at 10 paid up, shares are issued at 8 paid up. So there were different category of shares which were issued. There were different category of shares which were issued. So in this we have 100 shareholders. In this we have 50 shareholders. So the total shareholders of the company are 150. Okay, but these are different classes of shares. These are different classes of shares. So if we want to compromise, we want to enter into any scheme of compromise or arrangement with this class of shareholders, we are talking about this particular class. Likewise, we have all the creditors or just one class of creditors. Maybe the ones who have certain 9% debentures. So it can be one class of creditors or members, or all the members, all the creditors. Now come to the chart. Who can send the application for compromise or arrangement? Who would want to compromise? Who would want to compromise? It can be the company. At the first place, I can say that the company would want to enter into the scheme of compromise or arrangement. Secondly, it can even be the creditors, because creditors are afraid that if let's enter into some scheme of compromise or arrangement, otherwise I will not be able to get what I'm getting. Okay, what I can get. It can it can be the liquidator also. Who is a liquidator? When the proceedings of winding up commence, a liquidator is appointed. A liquidator is appointed who looks after the whole process of winding up. See, what do we mean by winding up? What is actually winding up? Winding up means closing the business or activities of the company, closing the business or activities of the company. That is exactly sale of assets and payment of debts. Payment of debts. To carry out this whole process, this is not going to be done by the directors themselves now. Why? Because the directors may favor the company, they will pay to someone, they will not pay to someone. There is an order in which payment should be made. Whatever assets are sold off of the company and whatever money is realized, that has to be made, that has to be utilized for making payment in the order which is given in law, which all you will read later. Okay, so for this particular purpose, a liquidator is appointed. Now, when a liquidator is appointed, the liquidator would want to arrange and set of things in the best possible manner. Liquidator sees that the assets of the company have realized 150 crores, whereas the debts to be paid are 300 crores, which is impossible to pay. So one of the creditors, we want to enter into a scheme of arrangement with them. We want to enter into a scheme of compromise with them, wherein we are offering them that you have a debt of 8 crores and we can actually pay you 5 crores for the same. Is it acceptable to you or not? So it is an excellent scheme which has been made by the liquidator, which liquidator believes that can actually help the company revive the situation or do the proceedings smoothly, anything like that. I'm not telling you the reason right now. Okay, so quite possible the company, the creditors, the liquidators, or even the members of the company. Just like you have creditors, the same way you have members also. Ma'am, how members will enter into a scheme of compromise or arrangement? Supposedly, members have a dividend. let's say preference shareholders, or they have a dividend, they have areas of dividend for 3 years. For 3 years, we want to enter into a scheme of compromise with them, where we want to tell them that waive off dividend for 2 years. We are going to pay you dividend for 1 year which is due, but you have to let go dividend of 2 years. Quite possible. Quite possible. That is a scheme of arrangement, scheme of compromise with the members, right? So the members, the creditors, the liquidator or the company, any of them can make an application to the tribunal. In form NCLT 1. In form LCLT 1. These forms are not so important. It was given in Rule 3, which tells us about the whole process of application for the meeting. Okay. So members, creditors, liquidator or company, they are going to send an application to the tribunal. For what? Because they have come up with a scheme of compromise or arrangement that they want to enter. They cannot enter just like that. I told you, no company is permitted to enter into any scheme of compromise or arrangement just like that. They have to seek necessary approvals. Who is going to grant them approval? NCLT, that is the tribunal. Tribunal has the option to accept or even reject. NCLT feels that you are proposing a scheme which is very unreal. You are saying that you owe to the creditors. Supposedly company has proposed a scheme or arrangement to the tribunal, and company owes an amount of 10 lakhs to the creditors. But the company in its scheme is proposing that we will be paying only 1 lakh to the creditors and we want the creditors to waive off 9 lakhs. Tribunal finds it very harsh and unjustified. Tribunal thinks that forget me, even your creditors are not going to approve this. Have you taken permission from your creditors? Your creditors are even not going to approve this. So this scheme doesn't actually looks like that it is going to turn into a fruitful or a beneficial compromise. So I reject the same. They are going to reject the same. Possible? And if tribunal finds that yes, this is a correct scheme and it is going to be beneficial for the company also, the company will be able to revive from those financial difficulties and the creditors will also be happy. Okay, so in this situation, NCLT has accepted this scheme. Once NCLT accepts the scheme, NCLT may order to hold meeting of relevant class with whoever. Supposedly there is a group of creditors with whom you want to enter into this particular compromise. Okay, so with those class of creditors, with those debenture holders, with those class of creditors, the company has to hold meeting. Company will call a class meeting in this case. Why? Because tribunal has instructed them to do so. Tribunal has told them that call a meeting of that particular class, seek their permission and then tell me what happened in the meeting. If your creditors have permitted the same, then I am going to sanction the scheme. Tribunal has right now only accepted your proposal. It has not given you a sanction to actually execute this. Okay, you have furnished your request to tribunal. The tribunal finds it justified. So tribunal has ordered you call their meeting. Call their meeting. How will you call the meeting? The chairperson is going to send the notice to the creditors, members, debenture holders or any class of them, whichever is the relevant one. Meeting is going to be held, voting is going to be done, consent will be obtained, and then tribunal is going to sanction the scheme. Once tribunal sanctions the scheme, it is going to send the order to the company for compromise or arrangement, which has to be furnished to registrar. This is the basic and simple process. Now we will insert the complications. Okay, the complications basically additional points, fine? So compromise between whom? Compromise or arrangement may be between the company, may be made, check out this, between a company and its creditors, between a company and its members. Application can be sent by whom? By the company, creditor, member, or in case the company which is being wound up, by the liquidator. Okay, the liquidator, where is it appointed? It is appointed under IBC or as the case may be, order a meeting of creditors. So tribunal, after receiving this application, may, that means it is at the discretion of the tribunal, maybe order a meeting, as the case may be, whatever is the case, it is going to order a meeting of the creditors or class of creditors or members or class of members, as the case may be, to be called, held and conducted in the manner in which tribunal is directing. So tribunal may say you have to send application like this, you have to call the meeting within 20 days, this has to be done in the meeting, this has to be done. So tribunal has reserved the powers to direct in what manner this particular meeting is going to be held and conducted. Application is submitted in NCLT 1 along with these 4 points. Along with these 4 points. What are the 4 points? Notice of admission in NCLT 2. Not so important. Affidavit in NCLT 6, copy of scheme, fees. This is the whole process or steps which are given in your material. So apart from the chart, here also I have designed it specifically stepwise so that you are not confused with what is the process. First of all, you have to make an application to NCLT in NCLT 1 by whom? Along with the application, you are going to attach what is the scheme of compromise. Unless you tell the tribunal that this is the scheme that we have designed, tribunal cannot accept or reject it. Tribunal must know about the scheme. So you are going to give the scheme and you are also going to give an affidavit. Affidavit, what is affidavit? You all know what is affidavit, but what kind of affidavit has to be given? Affidavit. See, when proper evidences are not available, we resort to affidavit. What is affidavit? Supposedly, I have lost any of my important document. I am going to prepare an affidavit that I have lost this particular document and this may be reissued to me. So this is a legal proof that I have lost this particular document. Okay, so it acts as a legal evidence. Affidavit, because it cannot be prepared by us. If we go to the notary, we get it done. Material facts about the scheme. What is the company's latest financial position, the auditor's report and investigation. So these are the material facts which must be disclosed through affidavit, through affidavit. Okay, next is reduction of share capital or scheme of corporate debt restructuring. Scheme of corporate debt restructuring. See, if I talk about, let's say, first thing that you have seen here is latest financial position of the company, which is easily available, that's not a problem. Auditor's report is also easily available, that should also not be a problem. The third is investigation, if any, pending. Supposedly there is some investigation proceeding going on against the company, because any company which wants to enter into any scheme of compromise or arrangement is not a normal company. It definitely has some problems. So quite possible some investigation proceedings is going on, right? So if that is going on, you will give the details of that also. If you want to go for reduction of share capital, I hope you know what is reduction of share capital, then that has to be included. And if you want to go for corporate debt restructuring is what? Debt restructuring, a very simplified manner. You have to understand, company has some debt, it wants to restructure the same. Supposedly we have 9% debentures, we want to restructure it as 5% debentures. We have some interest in areas, we want to waive them off. So we are restructuring our debt. So the details about the corporate debt restructuring and scheme of corporate debt restructuring, whatever it is, has to be accompanied with the application. After that, disclosure of affidavit, here it is given. All material facts relating to the company, such as latest financial position, auditors' reports, pendency of any investigation, reduction of share capital, scheme of corporate debt restructuring, consented by not less than 75% of the secured creditors in value. That means, see, if any corporate debt restructuring is taking place, tribunal will not actually grant or accept or call the meeting of the same unless it is sure that at least someone is there who has agreed. So it should be consented by secured creditors at least 75% beforehand only. Okay. Including the responsibility statement, the safeguards, report by auditor, where the company proposes to adopt CDR guidelines by RBI, a statement to that effect, valuation report, everything. See, these are not so important, but I think with the plain reading you will be able to understand and relate it. So all these points will be added, and they have to be disclosed through affidavit, and they will be attached to the application. They will be attached to the application which is made to NCLT for compromise or arrangement. After that, sending of notice. After that, sending of notice. What kind of disclosure is not written in the chart? So for this particular disclosure you will have to look through the proper notes only. Okay, so NCLT has accepted, it is going to order to hold meeting for the relevant class. How the meeting will be held? Where a meeting is proposed to be called in pursuance of an order of tribunal. So tribunal has ordered that meeting should be called. Notice is going to be sent to all the creditors or any class, and to all the members or any class, and to the debenture holders individually at the registered office of the company. Now when I'm talking about notice, we have these 4 different points of relating to notice. You have to send notice individually to these, you have to send notice through advertisement, website, as well as to the statutory authorities. So with respect to notice, we have these 4 points which we need to discuss. Meeting is proposed, notice has to be sent to all of them individually at the registered address. Notice is going to be accompanied with, see, when you are sending notice, why you are sending notice? We are entering into one scheme with our scheme of compromise with some of our members, with a class of our members. We have sent notice to that particular class of our members, and with that particular class of our members, and when we are calling them to vote on this particular, whether the scheme can be is approved by you all or not. When I am calling someone to discuss on this matter, they must have the information beforehand of what is the compromise or arrangement, what is the valuation report, what is going to be the effect of this compromise and arrangement, and any other relevant matter. What here, I hope you have understood the details and the effect, but what do we mean by valuation report? What do we mean by valuation report? Valuation report can be required in different cases. Supposedly we want to enter into any scheme of compromise with our shareholders, that you provide us, or we are going to waive this or you waive that, and for that particular purpose we want to determine the share price. The share price. We want to cancel some shares, supposedly we want to determine the share price. That is going to be decided by the registered valuer only. So registered valuer has given you a share price of say 70. So valuation report may also be required. Report may also be required for some assets. Company has some assets, plant and machinery or something like that. Okay, and that assets in our books actually are 200 crores. In our books they are actually 200 crores, and we think that we are going to sell this particular plant and machinery, and after selling this plant and machinery we are going to pay off the dividend of one financial year. The dividend is 300 crores. So we are telling that by selling this plant and machinery, we will realize 200 crores and then we will pay your dividend of 200 crores. Please waive the dividend of 100 crores. So this is the scheme of arrangement or compromise that we are entering into. So this plant and machinery has to be actually valued by the registered valuer. We cannot believe in these figures. We do not know whether it actually has that value or not. The whole purpose, the sanctioning of scheme and everything is done, and after that we realize that no, this plant and machinery is only going to fetch us 10 crores. So you take only 10 crores. So the purpose of scheme will not be justified, right? So valuation report may also be required, fine. So chairperson is going to send notice to them along with these details. So it is going to be accompanied by a statement disclosing details of the compromise or arrangement, valuation report, explaining the effect, what effect it may hold, explaining the effect on the interest of directors and other matters as may be prescribed. Notice and other documents shall also be placed on the website. So I have written here to be placed on website. And if any, of course, if the company doesn't have website, where will you place it? And in case of listed company, these documents shall be sent to SEBI also. If the company is listed, it is going to be sent to SEBI also, where your stock, it is the authority which deals with stock exchange, and wherever your securities are listed, to that particular stock exchange also. And shall also be published in newspapers, I think you write here, okay. Shall also be issued by advertisement. So shall also be published in newspapers in the manner as may be prescribed. The notice of meeting is also issued, where the notice of meeting is also issued by advertisement. It shall indicate time within which copies of arrangements shall be made free of charge at the registered office of the company. See, there can be some shareholders, some members, some creditors whose individual addresses are not correct, which are available with the company. Company, while sending notice, is going to send at the address which is available with the company. Supposedly it's incorrect, supposedly someone is out of town, supposedly someone is for a holiday and he is unable to receive that notice. For that particular purpose, it is also placed at the website. Now, not everyone is going to check the website every now and then. It is also issued through advertisement in the newspaper. Now, if anyone sees the advertisement in the newspaper, they will be able to realize that, okay, there is a scheme of arrangement or compromise that is going to be discussed in the upcoming meeting. Now, where do I get the details from? Because had I received that individual notice, I would have got all the details. Through advertisement, I may not get all the details, right? So, in the advertisement, it is going to be written that from this particular date all the details will be available at the registered office. So any concerned person can walk in at the registered office and can see them. Okay. Now these are the details of notice only. I have told you, still there is rule 6, you don't need to learn it in so much detail. CAA 2 is the notice. It is going to be sent by the chairperson. How can it be sent? By registered post, speed post, courier, email, hand delivery. Then what is going to be the enclosure? I have told you all the important enclosures. Okay, so don't need to worry. The advertisement is going to be in CAA 2. And again, you don't need to worry about it a lot. So far, I think things are clear. Members or creditors or liquidator or company, they have sent the application to NCLT, may accept and reject. These are going to be the enclosures with application. NCLT is going to order to hold meeting. For that, chairperson will send individual notices to all of them in just a second. Right. Is going to send individual notices to all of them along with these details. Apart from that, notice is also going to be issued by advertisement, placed on website, and this is something that I haven't told you yet, right? Now, before I discuss this voting part, I am going to discuss this part. A notice in form CAA3 along with all the documents which have been prescribed shall also be sent to these authorities. Income tax, CG, Reserve Bank, Competition Commission, RBI, Stock Exchange, Registrar, any other sectoral or authorities which are likely to be affected. If you fall in the insurance sector, maybe IRDA, anything like that, any other authority. Why these authorities are also sent the notice of compromise or arrangement? Maybe income tax authorities have some objection. The company just filed the return, and in the return they have found something which is contradictory to this particular scheme or the arrangement or that particular situation that they are projecting, and income tax authorities feel that this particular scheme should not take place. It is not in the best interest of these creditors. It is not in the best interest of the company. Competition Commission of India, maybe competition, whenever the companies actually merge or the companies amalgamate or there is any internal restructuring, it affects the overall market also. CCI is the authority which helps to promote competition but curb the anti-competitive practices. Right. So maybe they also have some objection, maybe central government, maybe RBI, SEBI, Stock Exchange, any of them can be affected through this scheme or arrangement in a manner that is not known to us. So we are just giving them an opportunity. Maybe central government has a lot of dues pending, and central government thinks that if they enter into this particular scheme or arrangement and they are going to sell all these assets and pay off the debts of these creditors, how will we recover money from such a company? So many possible cases are there. These authorities have the right to know about this compromise and arrangement. If it doesn't concern them, they will just stay silent. But if it is likely to affect them, they will raise an objection that no, this particular scheme or arrangement should not take place. Okay, so this is going to be the notice, and if they desire to make any representation, the same shall be sent to tribunal within 30 days from the receipt of notice. So all these authorities, when they receive notice within 30 days, they can send the representation. And if within 30 days no representation is received by them, it will be considered that they do not have any problem. Okay. Now we come to the voting part. See, once again, so this particular chart also, let me just quickly brief you. You send that application to NCLT. Along with application, there were certain attachments. There was disclosure by affidavit. Then calling and sending of notice of meeting on tribunal's order. Then comes the voting on scheme, and actually before voting only, this is also sent notice to other authorities, and now we have turned to voting. We'll come to voting. Right. The persons to whom notice is sent may vote in the meeting either themselves. If they are unable to attend meeting, they can even send their proxies, or through postal ballot. So the adoption of compromise or arrangement within 1 month from the date of receipt of such notice. So they will have a tenure of 1 month. When they have received notice, within 1 month they can vote through postal ballot also. Now this is one point. This is one point which is actually a hindrance to the whole process of scheme of compromise or arrangement. So far, if I sum it up, what I've seen is notice is sent, sorry, not notice, but I would say application is sent to NCLT. NCLT has given an order to send notice. Notice is sent to relevant members, creditors, whatever it is, relevant people, right? How? Individual notice also, then website also, and through advertisement also, plus statutory authorities also. Now they are going to vote at meeting. So far I think things are clear. Okay. Any objection to the compromise or arrangement shall be made only by persons holding not less than 10% of the shareholding or having outstanding debt amounting to 5% of the total outstanding debt as per the latest audited financial statements. So they have the power to raise objection. Who has the power to raise objection? Who can raise objection, or who can, in case of members and in case of debt, it is 1/10, it is 1/5, right? It is 1/10 of shareholding and it is 1/5 of outstanding debt. Voting, this is clear now. Where were we? Right. Where at the meeting, majority of the persons representing 3/4 in value, voting by voting in person or proxy or by postal ballot, agree to the compromise or arrangement, and if such compromise is sanctioned by the tribunal, the same shall be binding. That means by voting, this is a different point, by voting we need consent. Now consent here is not written that we need an ordinary resolution or a special resolution. Why? Because resolution word is used for the decision by shareholders or the members. Here we are talking about creditors also or something, and ordinary resolution and special resolution is not going to serve our purpose, because we need, no doubt we need the consent of 3/4 people, but not exactly or directly 3/4 people. We need the consent of majority of people, but they should also hold 3/4 in value of the shareholding. That means supposedly I say there are 9 members. Okay. What will be the majority? Majority will be 5 members. So supposedly 5 members agreed to sanction this compromise or arrangement. We will not say that we have obtained the consent unless we confirm the second condition also. Supposedly there 9 members have a paid up capital of 1 lakh. That means the paid up capital of the company is 1 lakh. The total capital of the company is 1 lakh, and there are 9 members who are holding this capital 1 lakh. Okay. Now, when I sum total A, B, C, D, E, these 5 members who have agreed to sanction and who have agreed to the scheme of compromise or arrangement, if I sum total their shareholding, in value, it is going to come to say, let's say 24,000. Only 24,000. Only 24,000. That means the majority of shareholding in value is with the leftover 4 members who have not agreed. So this will not be the consent. This will not be the consent. Now supposedly they have this much shareholding. This is the consent. Why? Because they should also have 3/4 in value. 3/4 in value. Whatever is the total share capital, whatever is the total amount of debt, if it is amount of debt, we'll see 1/5. Sorry, if it is the amount of debt, that doesn't matter. We have to see 3/4 in value. Doesn't matter whether it's debt or whether it's members. That 1/5 and 1/10 is for raising objection. Okay, so I hope it is clear. If we come to the chart, after the notice is received, meeting is held, voting has happened, and we need the consent of members, creditors. Majority in number representing 3/4 value is required. If it is passed, then only we will proceed. Then only we will proceed with the other part. Now, the chairperson within 3 days of conclusion of the meeting is going to submit a report to the tribunal. Not so important. After which. Where the proposed scheme is agreed by the members, the company within 7 days of filing report present a petition to tribunal for sanction of scheme. Tribunal is going to fix a date for the hearing of petition and is going to sanction the scheme. See, all these rules, report of meeting to the tribunal is not so important, but we have till rule 17. The ultimate conclusion of rule 17 is that tribunal may sanction the scheme. So if you want to read it in detail, you can read it and know it, but it's not so important. Fine. Okay, now we have the contents of order of tribunal. This is one addition that we also need the certificate from auditor. As I told you, how you are going to present it into the books of accounts, that is also important. So accounting, how you are going to take care of the accounting, will you comply with all the accounting standards? So we need a certificate from auditor in that regard also. So once we have obtained that and given the same to tribunal, tribunal is going to sanction the scheme. Of course, while sanctioning the scheme, it is also going to consider the objections which are raised by the statutory authorities. Okay. And what then after sanctioning, it is going to send the order of sanction to the company. Within 30 days, company has to file the same to the registrar, and this particular sanction order is going to bind the company, creditors, members, liquidators, contributories, everyone. Now, what will be included in the order of tribunal, that is the contents of order, that we are going to see under subsection 7 here. An order made by the tribunal shall provide for any or all of the following matters, whatever is relevant to the case, where the compromise provides for conversion of preference shares into equity shares, or such preference shares will be given an option to obtain areas of dividend in cash or accept equity shares. So whatever, however, whatever on condition, on whichever condition you have sanctioned the scheme, you are going to mention them. That we had got the scheme of compromise of converting the preference shares into the equity shares, right? And this has been sanctioned. Now, how are they going to accept the areas of dividend? Are they going to, will they be given an option that they can take it into cash? Since cash is not available in with the company, they can get extra equity shares for the same. The protection of any class of creditors. You will write in the order that such arrangements for protecting this particular class of creditors should be made and submitted. So you can give any directions. If the compromise results in variation of shareholders' rights, section 48 talks about DVR, right? Variation of shareholders' right. That means earlier shareholder was entitled 1 share, 1 vote. Or maybe now he has been taken away that dividend, 1 share, the dividend was paid based on his shareholding. Now the dividend will not be paid. Now the dividend will be paid like 10 shares and then 1 dividend, something like that. Maybe the terms are being altered. So whatever the terms are being altered, they have to be given effect in compliance with section 48. See, if you are doing buyback, you have to comply with the section of buyback. If you are doing reduction of capital, you have to comply with the reduction of capital provisions. So all such provisions will be complied with, and so the same thing will also be written in the order of tribunal. So tribunal is going to mention all these points, that if there is any dissenting shareholder, he should be given an exit offer. That you don't agree to be converted into equity shareholders, here is your cash, you take it and you can go. If the compromise or arrangement is agreed by the creditors, then if there is any proceeding pending before BIFR, shall abate. BIFR is Board of Industrial and Financial Reconstruction for reviving the companies. Now actually revival and rehabilitation of sick companies chapter has been omitted because of IBC, Insolvency and Bankruptcy Code, but this BIFR, if they have the company before them, it has become a sick company and it is in the process of rehabilitation, and in the meanwhile the creditors have agreed that we agree to accept lesser amount, so such BIFR proceedings are no more required, so they shall end and the company shall go on. Okay, so no compromise or arrangement shall be sanctioned by tribunal unless a certificate of company's auditor has been filed with. This I have told you. This also I have told you. Now, the tribunal may dispense the calling of meetings. See, here I have written this particular point also. After NCLT has accepted this application, it has to order the meeting, but this meeting may not be held if already 90% members or 90% creditors have given you the application. So if already the consent of 90% members is obtained, why do we need to conduct meeting? Meeting is not required, because if they have already given, 90% people have given the consent, that means you have all the consent. You can directly and straight away, seeing all the things and compliances, you can send the you can sanction the scheme. So this tribunal has the option of dispensing with the calling of notice, with the calling of meeting, if 90% value they have agreed and confirmed by the way of affidavit. Buyback in accordance with section 68. If it is a listed company, then you have to follow the regulations of SEBI. And if there is any aggrieved party, it can make the application to tribunal and can share the grievances, and tribunal is going to pass the orders as it may deem fit. Reduction of capital according to section 66. Now we have two questions here. A meeting of members of Jaora Agricultural Equipments Limited was convened under the orders of tribunal for the purpose of considering a scheme of compromise and arrangement. The meeting was attended by 200 members holding 5 lakh shares. Okay, 70 members holding 4 lakh shares in the aggregate voted for the scheme. 120 members holding 90,000 shares in aggregate voted against the scheme. See, the total present were 200 with 5 lakh value. We have to check 70 members with 4 lakh value voted in favor, and 120 with 90,000 voted against, and 10 members, just 10 members with 10,000 shares did not vote. Now we are not concerned with who attended and who did not vote. We are not concerned with them. We are concerned with who actually voted. Right? So I should have written here because otherwise I will not be able to. So 200 members, 5 lakh shares, 70 members, then you had 4 lakh shares, then 120 members, this was favored, this is against, with 90,000. Then 10 members did not vote, right, with 10,000 value, right. So my first question is number of members who voted in favor or against. The ones who did not vote, doesn't matter how many of them actually voted, because whenever we want to check a resolution, how do we see the number of members present and voting? So how many actually voted? The number of members who voted is equal to 190. Is equal to 190, and the share value that they hold is 4,90,000. Now we have to check out of this 190 whether 70 is majority or not. Whether 70 is majority or not, I would say no. For 190 to be majority, if I divide 190 into half, it will be 95. 95 plus 1, 96 will be the majority. 96 will be majority. Right, and if I see 4,90,000, 3/4 of 4,90,000 will come out to be 3,67,500. So at least these many members holding this value should have voted in favor. Then only this particular consent would have been deemed to be obtained. Right, so I would say that the scheme has not been approved by requisite majority. Why? Because we have got this particular value majority but not in number, and that is also required. Now, the shareholders and creditors of Superfine Limited in a meeting convened for approval of scheme of restructuring of the company passed resolutions. The scheme of restructuring provided the following: sale of plant and machineries and this, unsecured creditors to forego 60%. A few shareholders and creditors raised objections against the said arrangements. Advise what steps can be taken for to give effect to the proposed scheme. You have to send the application. Along with the application, there has to be details. Notice will be called. Then notice has to be sent. Properly meeting has to be convened. 3/4 majority consent has to be obtained. Then it has to be given to the tribunal. The whole process you have to write here. Don't worry about anything else. Okay. So I hope section 230 is all clear. It was quite a long section, but I hope we have discussed it in a manner that it is all clear and you don't have any confusion at any step. Revise it once and see you in the next class with section number 231.